The next speaker we're going to invite up is John Reed. John Reed is a partner in the dispute resolution law firm of Beament Green, and specifically focuses on civil disputes, and not only serious personal injury, but medical issues as well. Originally from Brantford and the home of Six Nations, and also, I understand, a collector of art. Has an incredible art collection of Aboriginal artists in Canada. So, John, do you want to come up here? Give John a welcome. Oh, there you are.
So, what James Sinclair just said to me is, you've got no time, just do your best. And I want to thank Anna, who's walking over here, for asking me to come here. And I guess what I would say to you is, Niigaan in conversation is an interesting thing. You have people talking, speaking fabulously, as Claudette did, and you have people listening. And I think that my role here is really not to lecture to people or to speak. I could never hope to speak as well as Claudette has, but really to listen. And that's really why I've come here as much as anything. And when Anna gave me this subject, the Constitution, Section 35, and Bill C-45, I said, well, what about the subject of love? Can I come up here and talk about love? Do I really have to talk about all these things? Anyway, all right. There you are. I'm going to be very brief, as James says. And by the way, thank you very much to the organizers. They've done a great job here. I think one of the things that struck me as I read through a number of things before coming here is that really in many ways it was as simple as this. Nothing about us without us. So if you listen to those words, that's really what this is all about. It's not about people, whether that be the government or lawmakers or whoever, telling Native Canadians what to do. It's really nothing about us without us, which means a dialogue. And this dialogue has certainly been started with this Idle No More movement, starting in Saskatchewan and spreading rapidly. And I think that what I take out of that is it's been a catalyst for an open discussion, which is what I think is happening here today, regarding Indigenous rights and the relationship to all Canadians. And this conversation, in a day like today, like this afternoon, is an opportunity to discuss some of these issues and to listen, from my point of view, to Chief White Duck, to all of the people who have been speaking here, and to listen carefully. The conversation now, and I think this is what people are saying, is the time for Indigenous peoples and the settler community to come together and to try to build a bridge based on justice and harmony to the future. One of the things that I was reading keeps on bringing up the Good Red Road. And as I understand it, in the traditional Native Indian worldview, there are many references for following the Good Red Road. And it's important for all of us here to follow that Good Red Road so as to lead to a spiritually balanced, harmonious, respectful, fulfilling and meaningful life of growth, progressing into wisdom and maturity. Having said all of those words, we do have these various statutes, the law, and as just been said, these laws that have in many ways imposed on Indigenous people. One of them being the Indian Act. And I'm not here to talk about that, but does this act establish a regime where band leadership has no real say in political and legislative life on those reserves? Aboriginal rights. Aboriginal people were obviously in prior occupation of lands in Canada. And so these rights are asserted to guarantee the future use of lands in certain ways that the lands were used historically by Aboriginal people. Another concept is Aboriginal title. And this is a subcategory of Aboriginal rights. This is a kind of possessory right to the land itself. And we've heard from many of the people who've been speaking here, I think the central premise of what they're saying is that the land is central to the issues, that is the most important thing that people talk about. The The constitutional rights under Section 35 of the Constitution Act provide various things. They provide, firstly, that the existing Aboriginal and treaty rights of Aboriginal people of Canada are hereby recognized and affirmed, as if they had to say that. Aboriginal peoples of Canada include Indian, Inuit, and Métis people. Number 3, the treaty rights include rights that now exist by way of land claims agreements or may be so acquired. And 4, that Aboriginal and treaty rights are guaranteed equally to male and female persons. So why is this section so important? It provides a demarcation date after which the surviving Aboriginal and treaty rights can no longer be abolished by the federal government. In plain English, the Crown cannot extinguish Aboriginal and treaty rights by legislation after the passage of that Act. Now there's a difference between extinguishment and mere regulation. So for example, this whole concept of a right to fish, which can continue to exist even if it's placed under strict controls. So I'm going to just jump ahead. And duty to consult. Now it's obvious that the government acts in a fiduciary capacity with respect to Aboriginal peoples and must demonstrate restraint in exercising those powers. And so where Aboriginal and treaty rights have been interfered with by the government but not extinguished, consultation and accommodation are an essential part of, quote, the honourable process of reconciliation which is set out in this Section 35 of the Constitution Act. In a sense, it's going, is that a signal that I should stop talking? I can live with that. So in a sense, it comes back full circle to what I said, nothing about us without us. A duty to consult. Bill C-45. Does this bill, which is this large compendium bill, violate First Nations treaty rights? Was this legislation passed without proper consultation and debate? So it's passed third reading in the Commons, as I understand it. Former Aboriginal Affairs Minister John Duncan, who recently resigned, said, the feds are not going to repeal this bill. So this is the act to implement all kinds of provisions from the budget that was tabled in March of 2012. Now, it deals with various issues. It deals with this issue of leasing portions. It deals with the process of that. It's not really, I don't think there's any purpose in me going through that. It deals with this whole concept of changes to the Fisheries Act and Navigable Waters Protection Act, and it goes, I think, to what I think it was Chief White Duck talks about, the water being so important, not just to First Nations, but to all of us, and so that this bill will reduce the number of federally protected waterways. So again, all of this was done without any consultation. So I think, so the whole point of Bill C-45 and the whole point that was put on this agenda, other than to prevent me talking about love. Anyway, was really, I think, a very simple one. It's another example, not just for First Nations people, but for really all Canadians, of this government doing things without proper consultation, packaging it in a large compendium of bills so that almost no one understands what's going on, and essentially ramming these things down the throats, whether that be Indigenous people or other Canadians. So really, I think what I would say in closing, that it's been a privilege to be here. I have certainly learned far more by being here than I have attempted to impart to you. And next time, can I go on first before? In fact, actually, I'm thinking of giving up the practice of law to go back and enroll at the University of Ottawa so that I can be a student in her class.
More of a comment than it is a question. Kwekwe, Suzanne Kiptu Nadishnaka is also known as Suzanne Kranz. I just wanted to comment on Ms. Kamanda's opening remarks regarding the misnomer Indian. And it's also something that I read in the first few pages of Thomas King's new book, The Inconvenient Indian. And I want to share with the group today something that I learned long ago, and I don't even remember where I first heard this, but Christopher Columbus, in the time of 1492, the country that we now know as India did not exist by that name. And Christopher Columbus was an Italian who was hired by the Spaniards to explore. And part of his duty was to report back to his superiors. He wrote poor Spanish, and when he discovered the people of Turtle Island, he reported back that they were a people in Dios, a people of God, a spiritual people. And I would like to suggest that Indian is connected to our original teaching, that we are connected not only to nature, which connects us to spirit, and those bones that Gilbert White Duck spoke about, nurtures the earth and the trees and the flowers and the medicines. We are all connected spiritually, and it was our spirituality that was broken by the Christian missionaries, the newcomers, the residential school policies. And it is our spirituality that we must remember, that we must reclaim, that we must rediscover. And our spirituality is what connects us as human beings. And it's with our relationship to nature. It's not a political one. It's a spiritual one, because it serves to remind us that we are part of the great mystery of creation. And when our current government can strip our land and pollute our waters, he can do that, they can do that, because they have removed our collective connection to our spiritual existence, because it's through nature that we acquire our spirituality. So by the personification of God that removes us one step away from nature, that is what justifies the pollution of our world. And I really encourage everyone to personalize your politics. Start in your own home, in your own yard, in your own community. Think about what you are doing to the Earth Mother, and think of it from a spiritual perspective.
Niigaan for that, but I would throw that, to take it an extra step from that question, is how do you foster a language that is it's both challenging. So I think that what we've done in these two presentations is really take Section 35, which is at the end of the day really the duty to consult, and that Bill C-45, which is that break of that duty to consult, or that inability to. That's really the major complaint of the omnibus bill, is the inability to consult. How do we take that language and remake that language, which is what you're really talking about, is remaking words and remembering where those words come from, but also facilitate, not only challenge those peoples who are perhaps not consulting, but also invite them to the table. Because sometimes if you only focus on the challenging part, they never come to the table. And so I think that one thing this is kind of the elephant in the room question, is how do you get a government or anybody, because I don't think this is specifically about the government currently in question. There's a long string of this. How do we invite those members in decision-making powers to the table to talk, actually have the real life talking about what this relationship might look like? So.
Now you're the professor and I have to be the student answering. Niigaan? You'll be gone. Okay, first of all, before I answer that question, thank you, Suzanne, for that. I just wanted to add to that. You know, when I was growing up as a child, my grandfather William always said, always identify yourself as a North American Indian. Be proud of who you are as an Indian. And I personally rather be called an Indian than an Aboriginal, Native, or even Indigenous. I don't like those terms. First of all, I know who I am as a Anishinaabe. I know who I am. But I'd rather be called an Indian. And yes, absolutely, that history. Los Indios, those who are in God. And our ancestors and our elders have always told us, and in our creation stories, and that medicine, on that medicine wheel, we were the people that were gifted with spirit. So we carry that gift. Okay, so thank you for sharing that, Suzanne, as well, to remind me of that. So for all of you out there, if you want to talk who Claudette Commanda is, you make sure you say that Claudette Commanda is a North American Indian from the Algonquin people. All right? Okay, answer your question now. What did you ask again? Okay, how do we engage, right? What language do we use? Well, I know I could, invite people through our own First Nation language, but I know you're talking more about that political language or that governance language or a language of society, the legal language. I was getting to that. You're rushing me. Okay, sorry. We have to, it's like, and I will reflect back on what my teachers have told me, my elders and my grandfather was one of the greatest lawyers and judges around, was the old man William Commanda. And though many of you that know him, you can attest, you can back me up on that, right? You see, he said to me, the white man created laws against our people. There's going to come a day that we are going to understand those laws, and we are going to be educated in the white man's law. You're going to take his laws and you're going to give it back to him. You're going to speak his language, that legal jargon, and you're going to force him to have to honor his own law. And that's what we are doing when we see many of our young people, many of our people becoming educated through mainstream society. And another thing, what I believe is you have to feed them with love. Feed them with love. Kill them with kindness. But the old man also said, be direct. You have to tell them their history and their truth. But you kill them with kindness. And you open up your arms and continue educating them. So we have to take back Canada. Canada is a country that boasts its pride in its constitution. Its pride in how this country was created, and the Constitution of the British North American Act, and then Canada's other constitution in 1982. Got to give them back their constitution. Got to give them back the responsibility and empower Canada to be proud of its own laws. That's what's needed. Thank you.
I'm just going to make this very short. How do you respond and things like that? Well, I'd say this. You don't respond with jargon. You don't engage in the same kind of dialogue. You do, in a sense, such as this young woman spoke, bring a different language to the table. And it's a language of spirituality. It's based on the things that we've been hearing about throughout today. It's not constitutional talk. It's not legal jargon. By falling into that trap, you end up speaking the same language. And I think you need to speak a different language, such as been described here. That's it.
Oh, me glitch. Oh, I apologize. We only had time for one question for that session. Oh, geez, look, I turn into the bad guy here, right? Indian time. Is it very quick? Okay, and sorry, I'll get back to you. Okay, we got you. Okay, very quick. Yeah.
Cecilia Cal, is it working?
Yep.
Cecilia Cal, a Clutcho woman from the Northwest Territories, gave me permission to tell you that she won the first United Nations judgment against Canada for racism in February. And that's because of the government of the Northwest Territories illegally removed her name from her own home, and a non-Aboriginal husband kicked her out of her own home and her own community. And she won the United Nations judgment against Canada. And they have to give her back a house, they have to compensate her. She had 7 lawyers over 10 years in Canada. And she lost her case, not because she didn't have one, because they said she didn't pursue it in court. A First Nations woman from a tiny little community was held responsible for the failure of those lawyers. And so, you know, there's legal stuff too now that the United Nations has recommended to Canada. So if anyone's interested in those court decisions, that decision wasn't covered by the national media, and mainstream lawyers and judges are discrediting that judgment by the United Nations against Canada. So just to let you know, she stood by herself. No lawyers, no organizations, you know, nobody to really support her, but her own sense of what was right. So good news.
I just want to give you what Canada is.
Okay.
Canada is a borrowed word given to a political entity.
Okay, you bet. Yeah, one of the things I do with my undergrads is very first class. Is I have 200 undergrads in my first year class, Intro Native Peoples in Canada. Very first class, we talk about where's Canada come from. First thing I ask them, 200 hands don't go up. None of them go up. I say, where does the word come from? And the very first class, we talk about that history, and that is so eye-opening. It's just a minimal, tiny little thing, and I just explain to them where the word comes from and who spoke the word and where does it come from. And that blows their mind. I mean, it's just that tiny little thing. And these important speakers, Claudette and John, I can't say miigwech enough for being so brave and being at that front lines, because those front lines are so critically important, and dealing with those those trilogy decisions. I keep saying I happen to come from, my partner is a lawyer, and there she is over there. She hates it when I point her out, but wave over there. Lorena Fontaine, there she is, okay, over there. Right? And so she's a lawyer, and I keep saying to her, why can't we just get rid of those darn 3 decisions? Because those 3 decisions are just, every precedent so built on that idea. And so, I love that we're demanding a new relationship. So miigwech to the 2 of you.